Hello folks, as always jumping on here to give you a little tidbit about estate planning, talking to you about things that have come up with my clients recently. And as you can see from the title of this post, Asset Protection for Your Beneficiaries. By the way, I am Don Rolfe, the owner and founder of Northwest Legal Planning, an estate planning and probate firm located in West Linn, Oregon. So the reason that I'm bringing this up is I recently reviewed an estate plan that had some issues, I believe, with protecting what was being left for beneficiaries. And this is something that has come up several times in my practice that I've seen estate plans produced by other attorneys, or people had ideas of how they wanted to design their estate plan without thinking about, what's going to be best for their beneficiary and protecting those assets that they're leaving behind. So the case where the most recent trust that I reviewed and then other trusts that I have reviewed, the whole thought of leaving your assets to your beneficiaries in trust, one of them is protecting those assets, keeping them locked down, giving the beneficiary the full enjoyment of those assets, but at the same time having the ability to step aside and have a separate trustee appointed and keep those assets protected in case of creditors, predators, exes, all sorts of things. You never know what's going to happen in the future that could cause your beneficiary to perhaps lose a portion or all of the inheritance that you have left behind for them. However, this particular trust and other trusts that I have seen have mandated payouts of the principal from the beneficiary's trust to the beneficiary at set ages. So basically they will say something like the trustee shall pay to the beneficiary X percentage of the trust when they reach 30 years old, and X percentage when they reach 35, and X percentage and all of it when they reach 40. So by the time the child or the beneficiary is 40 years old, all of the assets have been paid out of that trust, and any benefit that they had for asset protection from that point forward is gone. Those assets are just in their own name. They're no longer held in a trust that could protect those assets. And really, that's just it's just poor planning. It's just not what you would want. You can give them access to a certain percentage at stated ages, but actually mandating that those percentages be paid out with language such as shall pay is a bad idea, because it does not give that beneficiary the benefit of being able to protect those assets for a longer period of time if it becomes necessary. So the way that we do this is we set up an estate plan for mom and dad. We're gonna make this a regular nuclear family, right? So we set up a trust, a revocable living trust for mom and dad. Inside of that trust, there are sub-trusts set up for Johnny and Sally, their 2 children. And all of the assets for mom and dad will be split in half and put into those trusts for Johnny and Sally separately. And those assets will stay in Johnny and Sally's separate trusts until such time as they're depleted. They have the ability to withdraw funds from them, to use the monies that are in there for their health, education, maintenance, and support. We may even set up that there are mandatory distributions, perhaps on an annual basis of a certain percentage, if the grantor or the person making the trust so desires that to be there. Give them withdrawal rights without making the withdrawals mandatory, and make those trusts last as long as the assets last. It does a couple of things. The number one thing is it can protect those assets in case something were to happen. Your child has to file for bankruptcy. They have a failed business. There's a fire at their business that they're held responsible for. Some sort of catastrophic event happens where they have creditors coming after them. If it's done in the appropriate manner, the assets that are in that trust will not be subject to those creditors. The second is keeping those funds separate from their own personal funds that they're earning. And this gives a couple of benefits. One of them is just that when they spend money out of the trust, they're going to remember, oh yeah, mom and dad left this to us. So mom and dad are paying for this vacation, paying for this car, paying for this medical bill, whatever it is that they're using the trust money for. They're going to remember, hey, this is from mom and dad. The second benefit is that it keeps those assets separate from their spouse. And unfortunately, the divorce rate that we have is astronomical. And by keeping those assets separate and protecting them from being part of the marital community or part of the marital assets, and if they're handled right, keeping them separate can protect a majority of those assets, or should be able to protect some of those assets during divorce. I'm not a divorce attorney. I don't know all of the intricacies in and outs in every state and the jurisdiction, but keeping those bifurcated and separated from the marital assets should protect them in that kind of situation. So, if you have any questions about this, or you have questions about estate planning in general, do feel free to reach out to me. You can book a meeting with me for free for 1/2 hour, either on the phone or in person. I prefer in person because I like seeing people. And you can do that by going to myestateplanmeeting.com. You can put yourself right on my calendar, and if you want it to do it by phone, I will pick up the phone and call you at the scheduled time. If we're going to do it in person, come on in. We can chat about your questions, talk about your what would be the right estate plan for you based upon your goals and objectives and your family. And at the very least, you might learn something that you didn't know before. And hey, if we're not a good fit, I'll even refer you to another estate planning attorney or two so that you can find the right person to work with. Again, I am Don Rolfe. We talked about protecting assets that you leave for your beneficiaries by making sure that the trusts are written in such a way as those funds can be protected from creditors, predators, and exes. And until next time, take care. Goodbye.